to this Facebook live chat. I'm Marc Levin, Vice President of Criminal Justice Policy at Texas Public Policy Foundation and Right on Crime, and it's a real honor and privilege to be joined by the Chief Justice of the Texas Supreme Court, Justice Nathan Hecht. I had the pleasure of working as a staff attorney at the Texas Supreme Court more than a decade ago and saw up close his brilliance, really a towering figure in Texas jurisprudence. And it's such a pleasure to have him join us here today. But we actually won't be discussing the cases of the Texas Supreme Court, as interesting as they are. We will be talking about fines and fees, as well as bail reform and related issues. And the Chief Justice, not everyone realizes this, but he exercises an oversight role over not just the civil justice system in Texas, but also the criminal justice system. Even though we also have a separate Texas Court of Criminal Appeals, the actual court system as a whole is under the Texas Supreme Court. So we've really been delighted that the Chief Justice has really taken a leadership role on several issues, including these topics within the criminal justice system. And I would argue largely because of that, some landmark legislation passed last session in Texas dealing with the issue of debtors' prisons, where people can be incarcerated because they're unable to pay a fine or a fee imposed by the government. And so we're going to start just by talking a little bit about those bills, House Bill 351 and Senate Bill 1913 from last session. And they went into effect on September 1st of last year. As some of you may remember, we were dealing with a pretty big hurricane at that time. It wasn't necessarily what everyone was concerned with, but those bills are already having an impact. And so, Justice Hecht, if you could talk a little bit about what that legislation was and why you pursued it.
Let me give you the history of it a little bit. In the Department of Justice investigation of the shooting in Ferguson, Missouri, the investigation concluded that the officer should not be charged. But while they were conducting that investigation, they were looking at the court system as a whole in Ferguson, and they found that there was a high imposition of fines and fees, costs in, we call them Class C misdemeanors. Every state calls them something different. But they're typically fine-only cases, traffic cases, small offenses. That there were multiple times, people could be subject to multiple times, multiple fees, multiple court costs. You get arrested for speeding and you miss your court date, and then you miss it again, and before you know it, you're owing hundreds of dollars, maybe thousands. So people were being jailed to enforce that. It was not a good system. And it had just kind of developed there without people paying a lot of attention. So there's a conference of chief justices of all the states and territories, and we meet twice a year. And so in November of that year, we got together for a meeting, and the leadership decided that we needed a task force to look into this. And then there had been some studies done on bail in the meantime. So we formed a national task force, and there were 4 chiefs on it: the Chief Justice of Ohio, of New Jersey, of Missouri, and myself. And we had about, I don't know, maybe 60, 80, 100 members of the group in consultative capacities, and from all over the political spectrum, from all sorts of disciplines, looking at all the aspects of this. And many of the groups had already done serious study of these issues. And it didn't take long. It was just a few months before everybody realized, all the states began to realize this was an issue for all of us. It was complex. The courts are different throughout the country. The nature of the crimes are different. Sometimes these courts are housed in the executive offices of the local government, so that the public can't tell where the mayor's office begins and the judge's office ends. There are lots of problems. They generate revenue. We looked at the caseload in Texas, round numbers. We have 8 million of these cases a year. The fines and fees collected are over $1 billion. About a third of that goes to the state. About 2/3 is kept by the local governments. So we have 2,100 judges in Texas that handle these cases, municipal judges and the justices of the peace. So it was a big issue for us. And at the same time, it was a big issue around the country. Everybody's kind of trying to figure out what's a good path forward. But one thing we felt like we needed to do right away was to look for alternatives to this. Come in, hear what your fine and the costs are, decide whether you can pay it or not, usually go to jail if you can, and leave the hearing, don't come back when you're supposed to, get arrested, then go to jail. We have hundreds of thousands of people in jail for these offenses, for these reasons. So we were looking at the problem from three principal perspectives. Just the liberty interest of the people involved, the defendants, making sure that this was being done according to the Constitution and the law. Secondly, the integrity of the judiciary. We were worried that sometimes these courts seem too close to the other branches of government. And then thirdly, from just the point of view of a very conservative view of taxpayers, they're paying for all this. They're paying for all these jail cells to keep these people who are not going anywhere, can't go anywhere, have not done anything, for the most part, terribly pernicious to society. They run a stop sign or something. And really, I mean, is the public going to pay $200 or $300 to keep that person in jail? So to teach them a lesson or keep them off the street, or what? It just was not making any sense. So our first step was to go to the judges and lay this out, because I said we've got 2,100 judges and we've got 806 justices of the peace and 1,294 municipal court judges. And so they've been doing this the same way for a long time. So we said, take a look at this. Read this information on how much, whether this makes sense or not, and tell us, come up with a response to it. And of course, lawyers, as you know, are very conservative people, not always politically, but they don't like change. So these judges were very skeptical of change, as they should have been. But in Texas, they have very strong educational groups. There's a Justice of the Peace training center. There's a municipal courts education center. We work very hard at trying to keep our judges trained and educated. And so as their leadership began to think about these issues, they came generally to the view that something should be done. Because I didn't want to take this to the legislature and then have my own third branch being critical of it. So, and there were lots of differences, and they were honest differences. And through that collaborative effort, I was talking to many of the municipal judges throughout the session, and they would say, we can change this or we can change that, and make it a whole lot better for us. I have a close relationship with them and with the justices of the peace. And so in that process, I thought we came up with a pretty strong bill.
Well, I have to agree, and you're right about the numbers. You look at it in 2015, in just 10 counties, 14,000 people were jailed for fine-only offenses, which speeding tickets, similar things like that. And so that's a big cost to the taxpayer, because you still don't collect the money. You can't get blood out of a turnip if somebody can't pay, and then the taxpayers are on the hook for the jail costs. So these two bills, Senate Bill 1913 and House Bill 351, which were virtually the same, Governor Abbott signed both of them, and And among other things, they said, the court can adjust the amount commensurate with someone's ability to pay at the outset of the case rather than waiting for them to become delinquent. It also increased the community service credit that people would get. So have you already seen some effects from these bills?
Yes, and the bills really did try to move the system in a better direction. They required that information about indigency and about alternatives like community service be printed on citations and notices. The judge has to tell you about that the first time you come in. If you don't show up for your next court date, the staff will call you or text you or get hold of you and say, you really need to come in and explain why you didn't show up the last time. Otherwise, the warrant's going to issue for your arrest. So lots of people come in and say, well, I'm sick, this. Even if a warrant has issued and the person comes in and says, has a reasonable explanation why they couldn't get there. I mean, keep in mind, these are very minor offenses. We're not talking about killers here. We're talking about people that are just trying to deal with everyday life. They have a chance to explain. The judges have more discretion to waive the fines and fees, and so we got some data. So it's been in effect since September the 1st. Although some several judges, were excited enough about it that they wanted to do it voluntarily before the statutes came in and said this is what you have to do. And it was up to the judges; they could do that if they wanted to. So they did that. So this is data since September the 1st. So I've broken it down into we're not there yet, better news and good news. So I'll start with the we're not there yet. Everything is trending the right way. The number of warrants issued is down. The number of capias issued is down.
And just so people know, capias is arrest basically.
Right, another kind of arrest warrant.
Right.
Yeah. But the caseload is down. Mm-hmm. So you have to take that into account. There should be fewer of these things because there are fewer cases. And why there are fewer cases, we don't know. It's all over the country, and we don't know what accounts, whether it's the economy or what accounts for it. But the caseload's down about a third, and warrants are down about 40%. So they're down even further than the cases. So that's good. We're hoping that trend continues and gets better. Better news is that the use of alternative sanctions like community service is increasing, even though the caseload's going down. So judges are trying harder to figure out ways of alternative service rather than just throwing people in jail. So the number of cases, the percent of cases is up. And part of that's due, I think, because of the educational effort with judges to say, you know what community service could be? Community service could be go take a job training course. Community service could be get your GED. It could be something, it doesn't have to be picking up trash on the side of the highway. It could be something that by the time the person gets through with it, the person is better off than before they were arrested in the first place. So it could be some of that. Jail credit, the number of people put in jail, the number of times that the credit is $100 a day. It takes off your fine and fee if you stay in jail. That's way down. The number of cases that it's being employed in is way down. It's down about 10%. So the savings to local governments and the public for the decline in having to jail these people should be significant. Now, the really good news, and this was kind of a surprise, is even though the caseload is trending down, more fines are being waived, more people are being given alternative community service, more people are claiming indigency and they're not able to pay at all. Even all of that considered, the per case collections, the amount of money collected per case is up 13%. And it's hard to know. I mean, we'll have to look at exactly why that is. But the anecdotal evidence is that the defendant is there, and the judge says, "Well, the fine is X, $200. The fine is $200." And the defendant said, "Well, I don't have $200." And the judge says, "Well, we can put you on a payment plan because those were authorized by law. Pay out $25 a month." So, well, I probably can't do that either. What about community service? Well, I got a job, and I'll lose my job if I don't have any more time. So, okay, I'll tell you what. Well, I'll reduce the fine to $160 if you'll pay it right now. And the defendant may say, okay, or he may say, I don't know. I guess, a friend of mine, family member, they can bring $150 over here. That's all. Mm-hmm. That's all I've got. So, okay, you wait right over there and call your friend and have him come in and pay the $150. Well, that's not only $150 that the court wouldn't have collected before. It's another $200 almost that the taxpayer saved by not putting the guy in jail. So the benefit to both the defendant and to the taxpayer is pretty good, and that's 13% is a pretty hefty increase. And all along, one of the criticisms of these changes was that no, you cut these people some slack, and it'll undercut the revenue. The revenue is used to fund the courts. It'll be a disaster, and it hadn't turned out that way.
Well, and I'm actually not that surprised, because in the San Antonio Municipal Court, before this bill passed it was almost 7 or 8 years ago, they stopped using jail and their collections went up. Yeah. Judge Bull talked about that from the municipal court in San Antonio, and similar phenomenon with probation fees, I think, helps explain this, because we hear anecdotally from probation officers that if their probationer doesn't have fees, and these are higher level cases, obviously someone's on probation, they have to pay a monthly fee, that sometimes they don't show up to their meeting if they don't have the money. And that's the worst thing they could do, because you can't be revoked from Texas from probation solely for not paying your fees, which was a bill passed, 6 or 7 years ago. But don't not show up and not have the money. But what that shows is people kind of just give up if they don't think they can make it.
Right.
And you're seeing the same thing here.
And being able to make it and not being able to make it, it's not that big a distance. Mm-hmm. To you, at least to you and me. The difference between a $160 fine and a $200 fine is not giant. But to the defendant, between making it and not making it, it can be all the difference in the world. So we'll keep looking. This state is coming in regularly. We're getting it from all the courts. With 2,100 courts, you don't get it all the time. So we're trying to make sure that the data collection is good, but we're cautiously hopeful.
Well, let me turn to another area relating to fines, which we did make headway on last session, called the Driver Responsibility Program. Mm-hmm. And what this involves is essentially if you have certain moving violations, like 1 DWI or 3 or more speeding tickets within a 12-month period, your driver's license is suspended unless you can come up with a surcharge. And this is true even if you took care of all those, you paid the tickets. But if you don't have a few $1,000s in some instances to come up with your surcharge through this driver responsibility program, which was created in 2003, your driver's license is suspended. So about 1.2 million Texans have their driver's license suspended as a result of this program, which was created with the purpose of supporting trauma care hospitals with this revenue. So once again, it's a revenue generating matter. So have you had a chance to look at that some and perhaps come to some recommendations?
Yes, we're beginning to look at it. Again, this is a problem throughout the country. Yep. Again, it's criminal enforcement not making as much sense as it should. I in my State of the Judiciary last year, I joked, I said, sometimes you're going to spank your kid, if you can still do that, and you say, this is going to hurt me more than it does you. My father never said that, but sometimes you say that. But the criminal justice system reminds me sometimes that we're hurting ourselves more than the people we're trying to punish, and it just doesn't make any sense. So the theory behind driver's license revocation is that people need to drive, and they'll do a lot to hold on to their license, and so this could be a big incentive to make them do better and follow the law more closely, and otherwise we'll take your license away. But it has a perverse incentive, because if you end up having your license revoked, what are you going to do? You're either going to give up your job, you give up going to the grocery store. What are you going to do? Or you're going to drive illegally. And if you drive illegally, it's more fines and fees, more revocation of life. It's just a never-ending cycle. So we need to find better ways of disincentivizing this criminal behavior that doesn't end up hurting people more than and not doing any good like the punishment.
Well, and to give folks a background, there was a bill, House Bill 2068 last session, which passed the House but didn't make it in the Senate. And one of the main holdup, the only holdup really, has been replacing the money. Now, most of the money is just kept on the budget as a kind of artificial device to help balance the budget. Only a minority of the money is actually given out to the trauma hospitals, but still, obviously, that's an important critical service that they provide. And so this legislation would have replaced that with new fines on, for example, first-time drunk driving, $3,000 up to $6,000 for repeat drunk driving. So now those fines ostensibly could be reduced under, well, I don't know, would this legislation have applied to, these are more significant crimes. So I don't know if people that couldn't pay those could have had those reduced or not, which is then run into the same problem. But the bottom line is, you're talking about shooting yourself in the foot. It's a similar issue, because Texans pay about $1 billion more in auto insurance premiums because of uninsured drivers, and people have trouble getting insurance policy if you don't have a valid license and they're driving anyway. So we just get back into the same rut here. And so we actually passed a model policy through the American Legislative Exchange Council, which is the national group of conservative legislators that I brought forward, that basically says states shouldn't suspend driver's licenses except for dangerous driving. So we do have a lot of driver's license suspensions, and I think that hopefully next session there'll be an effort to look at this and say, how can we replace this program and still take care of the trauma centers?
Right, and because it helps in so many different ways, these kinds of changes, there's a lot of just good government, bipartisan support for the bills in the legislature. The fines and fees bills passed, very easily in the Senate. They were closer in the House, but they still passed by a good margin. So we're hopeful we can say, look, you did the right thing last time. Let's do it again.
Well, let's turn to another issue that you, I think, did a great job of talking about in your State of the Judiciary address last year, which is the issue of bail reform and pretrial justice in Texas. And so this was an issue also that unfortunately there wasn't any headway made in the last session legislature. However, there's been some headway in the judicial system, but not in the state system, but rather in federal cases since the legislature adjourned. And so, of course, the issue here is people typically who are arrested will have to post bail, and normally the person doesn't have the amount of money themselves, so they hire a bail bondsman, and they typically will, the bondsman keeps 10% of the amount, whether the person shows up or not, and so you don't get that back, even if you do everything you're supposed to. But people who can't come up with even the 10% of the total money bail that's set, they just stay in jail. It could be months before their trial. And so there's been a move across the country to focus on a system based on risk assessment and objective analysis of someone's risk of not showing up in court, of being a fugitive, and of their risk of being rearrested, especially for something serious. And And so the case that started in the Harris County, and now there's one in Dallas, but the Harris County one went all the way to the Fifth Circuit, which resulted in an opinion which places certain limitations on the ability to continue to rely on money bail in Texas. And so I wanted to see if you could kind of share some of your thoughts on this and what the court's been doing and the Office of Court Administration to address this.
Yeah. This came out of the Ferguson Report as well, although bail reform has been talked about for 30 or 40 years. It made more progress in the federal courts than they have in the states. And since about the 90s, hardly any progress at all has been made in the states until recently. But the Ferguson Report, again, was just typical of courts around the country. The evidence was that people who were charged with, for the most part, not serious offenses, so that we're not talking about murderers, robbers, and terrorists, and sex offenders. These are serious crimes, driving while intoxicated, drug possession cases, more serious than the ones we've been talking about, but not so serious that the defendants are a real risk to society. Now, obviously, sometimes they are in DUI cases. Sometimes, any criminal conduct is indicative of misbehavior, of course. So there's that. But on the other side of that, judges have for a long time based the decision on whether to release someone who's been arrested, pending further hearing and trial, on the seriousness of the offense. And that's basically all they've been able to do. So sometimes they would look at criminal record, if they had that available to them, if the judge did. And the judge would say, well, to this defendant, you've been arrested 5 times, and, you don't seem to be able to, change your behavior, and so you could be a risk to society. I'm not sure. I can't tell for sure. And I don't know if you're going to come back or not. And so I'm going to set bail pretty high, maybe $9,000, maybe $10,000. Any number like that is likely to be so high that the person is not going to be able to even pay the premium to the bondsman to get off. Although there would be a number of people who could, and who just, say, fine, how much is it? And so the first problem is that the system shouldn't punish you for being poor. It's against the law, for one thing. It's unconstitutional to punish somebody just because they're poor. So this guy who has the money is going to be released. Now, this fellow who doesn't, even though he did exactly the same thing under exactly the same circumstances, is going to be jailed. And then again, there's the problem of the cost to taxpayers. So there was a story I talked about in the State of the Judiciary address last session. It was reported in the Dallas Morning News, and this grandmother shoplifted I think it was less than $200 in merchandise to give as presents to her grandkids. She got arrested. She'd been arrested before. The bond was set at several $1,000, $15,000, I think. Whatever it was way more than she could even dream about paying the premium for the bail bond. And she's locked up for like 6 weeks. So it costs the taxpayers $3,000 or $4,000 to lock her up. Then she's turned loose, so they don't get anything for her. The taxpayers don't get anything for her. And she's losing 6 weeks of her life and really done no good. So is that really what we want to do? So I think it's important, the use of bail, the use of money bail has to be examined top to bottom. But it's easiest to start with the bottom. So again, we're not talking about somebody that's killed 5 people and now, is he going to flee the state? And how many $1 million should the bail be? But we're just talking about these minor cases, of which there are thousands and thousands and thousands in Texas. And so in those cases, groups over the last several years have studied the demographics of people who recidivize, repeat offend, who flee when they're in trouble, who are violent and are going to take it out on the people that got them arrested. And so looking at 14, 15, 16 pieces of easily available data that technology can bring to the judge, you can, and this is the way it works, you can score the person. What is his risk to society? Is he likely to hurt anybody? Is he likely to reoffend? Is he likely to flee the jurisdiction and not reappear? And you get a number. Now, none of this has been available until just the last several years. It's been tested over and over and over again. The Texas A&M tested the Arnold program here in Texas, and the results are always the same. You get a much better idea, the judge does, a much better idea whether the person should be released or not, without anything other than maybe restrictions on where he can go, but no requirement of posting money or bail, and just a requirement that he should back up. And the judge has a better idea, can use the scoring to really make a smart decision in each one of these cases, and a relatively quick decision, without relying just on the nature of the offense and maybe the criminal record. So it's pieces of information like, where do you live? Do you own a home? Do you have a family? Do you have kids? Do you have a job? Basic kinds of demographic information that give you some idea of how the person relates to his community.
Well, and previous failures to appear, and of course, if you're looking, so you've got the pretrial risk assessment information system for Texas, which the Office of Court Administration is piloting in Dallas, and it also has separate scores for failure to appear, as well as a chance of rearrest and chance of rearrest for a violent offense. And on that one, you look at, does the person have a prior violent offense, for example? And so these, none of these are going to kind of override the judge's discretion, but they're going to inform the judge's discretion. Right.
So it gives the judge more information, lets him, he's better equipped to decide, that we call it in the criminal justice system, PR, personal recognizance. You're released on your promise to return.
Right.
And, but there's no other fine or penalty, monetary penalty imposed.
Right, and you may have to report to a pretrial services supervision officer, like if you're on probation, you may have electronic monitoring depending on your risk level and all of that. And, I think that it's so important, especially in light of the Fifth Circuit decision, which says, within 48 hours, somebody's entitled to this type of hearing.
Right.
And so what do you think the role of the court is going forward in terms of, obviously, it has power to create rules, and what do you think the legislature, there was the bill last session, which one of the elements was for the Office of Court Administration to promulgate this assessment. Fortunately, you already have the authority to do that and are piloting this. So where do you think we go from here on this?
Well, I think we try to encourage the courts to move in this direction. Again, when we started work on the fines and fees problems, my hope was that when the judges, the municipal judges and the justices of the peace saw what needed to be done, they would do it, and they did. They were, I think, very responsible. Texas can be proud of them, and I hope the same thing here. there's a lawsuit in Houston that this case that went to the Fifth Circuit came from. So there's a lot of harsh words being exchanged about how the system operates and why is it that way and whose fault is it and how can it be fixed and those sorts of things. But I think as time passes, the judges are going to see that knowing more is better than knowing less. Making an informed decision is better than making an uninformed decision. And the real tangible benefit to the public through the reduction in the number of people being jailed, it's just got to be a great thing. This number has shocked me, but in round numbers, 15, 17 years ago, 1/3 of the jail population in Texas was awaiting a court hearing. Now it's 2/3. And we're just drifting the wrong way. So there's a move to get back. Now the bill this time passed the Senate rather easily, and then got stalled in the House at the last minute. But I think we'll be back again, not to force changes that are ill-advised, but to really encourage judges across the state to move in this direction. And we've already got a number of volunteers. There are judges in Nueces County that said, we like this system better anyway. We're going to do it on our own. And so they don't need legislation to do that. They can just do it. It's up to the trial judge to decide whether to turn somebody loose.
Well, and just so people kind of understand what some of the issues are, in the Harris County lawsuit, it came out that 40% of the misdemeanor pretrial defendants were languishing in jail prior to their trial because they couldn't afford to post bail. And virtually all of them ended up pleading to time served. So the punishment occurred before the adjudication, which is the complete opposite of the way the justice system is designed. And so this does raise troubling constitutional questions. And one of the issues that, one of the questions is really whether we should have an amendment to the Texas Constitution, because the Texas Constitution now says bail can only be denied for capital murder, not regular murder, and in certain family violence cases. And therefore, it means courts, their only option for keeping people, and there are other people that need to be in jail pre-trial because of their dangerousness, that their only option is to set bail at an amount high enough so the person can't pay it, which actually isn't what bail was supposed to be designed to be. It was supposed to be a method of release. And so you would set it commensurate with somebody's ability to pay. I think from my sense is we may not be able to have a perfect system until we amend the Constitution, as New Jersey did, and they're having very good results, both in terms of jail reduction and public safety. But there are things short of that. The bill that you referenced originally had a companion constitutional amendment, but that ended up being jettisoned. But just, again, I think you're right. We have to start on the low end. That's where the biggest numbers are. That's where the problem is. Right. And I'm hoping that lawmakers can assist with that next session.
Yeah, and I was a little surprised the constitutional amendment met with resistance because the federal courts went to this system in 1983, and so it's been in the law there for a long time. But you're exactly right. There are some people who just cannot be released. They are a complete time bomb walking around, and if they get out of custody for a minute, the chances are very good they're going to do a lot of harm. But the more responsible way to do that is to say, because of this and this and this, we're not going to turn you loose. We're not going to release you because you're too big a threat. And do that instead of saying, okay, well, we're going to post the bond
at $1 billion, which was, like Richard Durst, who does know people, he had the money, so he gets to go out, and somebody like the grandma you talked about stays in.
Right. And it's also important to note that no release system is perfect. You cannot assure that someone who is arrested for a crime and released is not going to get in further trouble. There's no way to know that for sure. So whether you have a bail system or whether you have this risk assessment system, there are going to be people released who shouldn't have been. And judges are they're very conscious of that. The last thing any judge wants on his conscience is that he turns somebody loose when he shouldn't. But the response to that is that that's going to happen with money bail. It's going to happen with the risk assessment system. All the evidence that we've got so far shows it's going to happen less with the risk assessment system than it happens with.
And we're currently doing some additional papers on this topic as well. So I really appreciate your leadership on all these issues. And I'm so thankful to everyone who's tuned in to watch this chat. Some of you may know Justice Don Willett on the Texas Supreme Court, who's now on the Fifth Circuit, became famous for his incredible Twitter feed. And I think this will hopefully be the beginning of Chief Justice Hecht's fame on Facebook. So, well, I'm Marc Levin again with Texas Public Policy Foundation and Right on Crime. And thanks to all of you for being with us today.